The next common question I get is whether I need a single-member LLC or a multi-member LLC, and what is the difference? A single-member LLC is when there's only one owner, and that is typically a terrible idea unless that one owner is a holding company LLC. The reason being is a single-member LLC is not as strong against plaintiffs in court. The other kind of LLC is multi-member LLC. As I just alluded to in my prior answer to the previous question, a multi-member LLC means that there is more than one owner. And the reason why it's important that you have more than one owner of an LLC is then we have protections against plaintiffs. After all, one of the big distinctions and benefits of an LLC over a corporation is that a corporation simply has shareholders. All of us listening may own stock in Tesla or Apple or some other publicly traded company, but we have no relationship amongst each other. A judge is happy to give away my shares in Tesla to my plaintiff because the other shareholders are not harmed. That is not the case with LLCs. In an LLC, we are governed by a completely different set of rules or statutes in every state. There's corporation statutes and then there are partnership statutes. LLCs are governed by partnership statutes. What that means is that the members are partners with one another. They may have fiduciary duties or responsibilities to one another. If I sell my interest in an LLC to another partner, my existing partner may not be happy with that. And that's why typically in operating agreements, there are restrictions on transferability and being able to sell your ownership. Because me and my partner, we trusted one another to go into business with one another. Well, that operating agreement should protect against someone stepping into the shoes of my partner. And so when a plaintiff comes, we want the ability to have an arm's length partner that the judge needs to protect in LLC statutes against the plaintiff stepping in. And it's for this reason, in the operating agreement, it needs to explicitly say that someone who is not purchasing the membership interest and the LLC and its members are not otherwise approving the transfer of the membership interest should be an assignee. An assignee should be spelled out in the operating agreement as to not have voting rights and certain powers that a member otherwise would have.